From the Times and the Sunday Times, this is The Story. I'm Manveen Rana. In some ways, it's been the sound of the summer.
It's happening. Yes, it is. The pressure is mounting on the Prime Minister to change what he said to date about the ECHR.
And to do that, we must leave the European Convention on Human Rights.
This government, or any government, will only get a grip on the out-of-control illegal immigration by quitting the ECHR.
As it turns 75 this year, politicians of every hue seem ready to put the European Convention on Human Rights out for pasture. But what exactly is in the ECHR? And would leaving it make any real difference to the asylum system? The story today: should we leave the ECHR?
I'm Fraser Nelson. I'm a columnist for The Times.
Fraser, Parliament's just come back, and one of the first things that Yvette Cooper has had to address was immigration. Just talk us through sort of some of the latest plans and why part of the conversation around it seems to be about the ECHR.
Well, Keir Starmer announced that summer is over, but summer never really went away for Nigel Farage. He's been very busy throughout the summer, drawing attention to illegal immigration, small boat arrivals, and the hotel drama in Epping. Farage has had a stunningly successful campaign where he introduced the notion of lawless Britain, with the idea that using the sort of the border control problems as a metaphor for the collapse of law and order in general. Now, this has led Labour people to think, we really have to do something about the small boat arrivals.
Because it is the British way to do our bit alongside other countries to help those who need sanctuary. But the system has to be controlled and managed, based on fair and properly enforced rules, not chaos and exploitation driven by criminal smuggler gangs.
And the court injunction, which briefly, though it was overturned later, telling the people in the in Epping Hotel that they had to go away, led the government to think, right, what emergency buttons can we press? And Yvette Cooper has pressed one, basically delaying by 2 years the reunification of families of those granted refugee status.
And our reforms will also address the overly complex system for family migration, including changes to the way that Article 8 of the ECHR is interpreted.
But a lot of other people are saying now it's time to either pull out of the European Convention of Human Rights, which is used in a lot, if not all, cases for asylum seekers to stay here, or, I would argue slightly more sense, to suspend the UN Refugee Convention of 1951.
And we'll get into the difference between the two and the subtlety there, but it does feel like the ECHR in particular has become a real political hot potato in the last few years, and perhaps it's partly just because, unlike the Refugee Convention, it has Europe in the title. But just talk us through where Reform and Nigel Farage stand on the idea of the ECHR.
Well, Reform is promising basically a whole political reset, nothing short of a revolution, pulling out of the ECHR, the Refugee Convention, and much else besides. Mind you, he's also proposing to break from the idea of parliamentary democracy by having an entirely appointed cabinet and things. So Nigel Farage is promising radical solutions all round. But pulling out of the ECHR has got a lot more purchase amongst Conservatives. I mean, during the Tory leadership campaign, Robert Jenrick campaigned saying he wanted to pull out of ECHR. And Kemi Badenoch said, no, that's not necessary to do what we have to do. But a lot of Tories have come to see it as Brexit Mark II, that after pulling out of the EU, we now pull out of the ECHR. So it's taken this totemic rhetorical significance. And a lot of people talking in terms as if you were to get out of it, then the asylum problem would be fixed. Now, I argued in my last column that we can, if we want, pull out of it. Parliament could do anything it wants. If we did so tomorrow, we would still have the small boats crisis, we would still have the asylum problems, because their laws which they're using extend far wider than the ECHR, which was written into British law with the Human Rights Act in 1998.
We'll come back to Fraser in just a moment. But first, everyone's talking about it, but what is the ECHR and why do we have it? we turn to our in-house legal expert.
I'm Jonathan Ames. I'm the legal editor at The Times.
Jonathan, take us right back to the start. When did the ECHR come into being and why?
The convention was originally drafted in 1950. It didn't come into force until 3 years later under the Treaty of Rome as a treaty of the Council of Europe. And I mean, the short answer to what the convention is that it's become a bête noire of various politicians, not just in the UK, but certainly in the UK. But it wasn't always like that because British politicians, the British government, and indeed British lawyers very much had skin in the game in the drafting of the convention in 1950. It actually came into force with 42 signatories, including the UK, in 1953. And it consists of 14 articles, which are the core planks of the convention.
I'll ask you to talk through those in a moment. Before we do this, so it came into being with British lawyers helping to draft it, playing a big part in it. Churchill at the time was a huge supporter. Britain was one of the first countries to ratify it. Just remind us of the circumstances that led to it being drawn up. What was it designed for?
Well, the circumstances, I suppose, were very much the dreadful events in the Second World War, not least the concentration camps in Nazi Germany, and the Council of Europe decided that they wanted to ensure that there was a minimum standard of human rights or indeed a broad acceptance of core human rights that would prevent the atrocities that occurred during the Second World War.
And just to confirm, the ECHR has nothing actually to do with the EU.
That's absolutely right. They are not connected. The European Council has a much larger membership than the European Union, and the European Union has its own court, which is the Court of Justice of the European Union. They are not connected in any way.
And just tell us, what exactly is the ECHR?
Well, as I say, the convention consists of 14 articles, and they cover issues or rights such as the right to life, which is obviously pretty fundamental, freedom of assembly and thought, fair trial, the right to a fair trial, the right to practice the religion of your choice, the right to freedom of speech, and also, quite crucially, the right to privacy and family life, and as well as a prohibition on torture. The court is a crucial element, is a crucial byproduct of the convention. The court effectively is the dispute resolution chamber or body for allegations that convention rights have been breached. The court is based in Strasbourg and consists of judges that are drawn from the states that have signed the signatories to the convention.
And just talk us through the legal process here. So with the ECHR, judges in Britain have the ability to interpret how cases that come before them sort of fit into that legal infrastructure. How much freedom do the judges here have in their interpretation?
Well, the relationship between the UK and the convention and the Strasbourg court really solidified in 1998 when the then previous Labour government and the premiership of Tony Blair enacted the Human Rights Act 1998 in the UK. And that legislation effectively, even though Britain prior to that or the UK prior to that had been a signatory to the convention and subject to the Strasbourg court, British judges did not, as a matter of course, necessarily have to take into account human rights arguments and principles in rulings. But when the Act was brought in 1998, that effectively incorporated the convention rights and all the articles of the convention directly into UK law. But nonetheless, if a litigant felt that a British court had still got a judgment wrong, the Strasbourg court was the final arbiter, and to this day, litigants can still go to Strasbourg.
And Jonathan, talk us through how the ECHR is being invoked in the row around asylum. So if you were an asylum seeker arriving on the shores of the UK, talk us through the process and when the ECHR might become pertinent.
Well, asylum seekers are required to declare when they arrive in the UK that they are making an application for asylum. The process is that they make that application to the Home Office, and Home Office civil servants assess the applications. If an application is rejected by the Home Office, the appeal is to the first-tier tribunal, the Immigration and Appeals Tribunal. If the tribunal rejects the application, there is an appeal to the upper chamber of the Immigration and Asylum Tribunal. And once all domestic UK legal routes are exhausted, then claimants can still go to the Strasbourg court if they have a human rights argument. As I mentioned, the core articles, or the most important articles in relation to asylum claims in the UK, are Article 8, which is the right to privacy and to respect for family life, as well as, I suppose, slightly more tangentially, the prohibition on torture. So in other words, no one who falls under the ambit of the convention should be subjected to torture. But more importantly, the right to family life means that those, again, who come under the ambit of the convention are entitled to certain rights around their spouses and their children, and they're not to have their family life disturbed effectively or unnecessarily or unjustly disrupted. And what that means in practice, I suppose, is that owing to a backlog of cases, asylum applications at the Home Office, in many cases, asylum seekers have leave to remain in the UK while their applications are being heard. And that can take years in some cases. And during that time, applicants can marry, have children, form relationships. They would then argue that if a Home Office decision several years down the track is to deport them, that would be a breach of their right to family life, which has been established in the UK over a period of years. And indeed, that often happens, or not often, but that has happened, and there's some very high-profile cases of that happening in relation to asylum seekers who have been convicted of criminal offences in the UK. They are still able, because they've been in the UK for some years, to argue that deportation would breach their Article 8 rights.
Jonathan, there is obviously currently a huge political debate around this. If the UK did decide to withdraw, just talk us through the mechanism. How does that happen?
In principle, because the convention is a foreign treaty, the government could invoke its prerogative powers and use secondary legislation to withdraw without requiring the approval of Parliament. But in the wake of the bitter rows around Brexit and the trauma of Brexit, one imagines that the government would, especially this government with a significant majority, would seek the approval of Parliament to come out of the ECHR. But coming out of the ECHR is only part of the equation. The convention is embedded currently in UK legislation under the Human Rights Act. So the Human Rights Act itself would have to be jettisoned, and that would require an Act of Parliament. And despite the fact the government has a significant majority in the Commons, there's certainly an argument around whether the House of Lords would agree that coming out was a good thing, and the government could face considerable opposition in the Lords.
Jonathan, you talked us through the ECHR, a really useful potted guide, which I think most of us needed. Just tell us a little bit about the UN Refugee Convention and how that affects our laws.
Well, the Refugee Convention is only a year younger than the ECHR, and it really does have a crucial role to play in this debate, because even if the UK comes out of the European Human Rights Convention, even if it jettisons the domestic legislation of the Human Rights Act, Britain would remain a member of the UN Convention in 1951 on refugees, and that also has some elements to it that would be arguable in the domestic courts by asylum seekers. And the core principle of the convention is something known as non-refoulement, which asserts that a refugee should not be returned to a country where that person might face serious threats to their life or freedom. And the convention goes on to define a refugee as someone who, owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group or political opinion, that's what qualifies someone as a refugee if they find themselves having to flee their home country. So the 1951 UN Convention arguably still would create continuing problems, in inverted commas, for any government that was trying to reform or amend the rights of asylum seekers and their recourse to legal argument.
Fraser, you mentioned that the cries against the ECHR have sort of arisen actually from all over the political spectrum now. Tell us about some of the voices who have suddenly been coming out against the ECHR.
Well, I think this is what really makes the difference. I mean, so far there's always been Eurosceptics saying, look, let's just complete Brexit and pull out of the ECHR. But what we're hearing now are Labour heavyweights, Labour grandees, Jack Straw, David Blunkett, both former Home Secretaries, both of them writing to the Times, and both of them making the same point, that the asylum crisis is so great, it is now time to derogate from certain laws and certain structures. Jack Straw was basically saying that he thinks his Human Rights Act is enough to guarantee human rights in Britain. He thinks that we can remove the clause obliging judges to look at what's happening in Strasbourg. Lord Blunkett is saying that we could derogate from certain clauses to try to get the asylum crisis down. But I'm more taken by Lord Ken MacDonald. Now, he was Keir Starmer's predecessor as Director of Public Prosecutions. He went into the Lords as Lib Dem, so again, hardly a right-winger. Now, I spoke to him last week and he said, look, the ECHR is just a red herring. It doesn't do what people think it does. The real law or treaty to reform is the UN Convention, which obliges Britain to basically give support or sanctuary to anybody who turns up with a well-founded fear of persecution. That's the phrase. Now, there's nothing wrong in the sentiment there. It was perfectly doable for the first 50, 60 years. The problem is now so many more people are on the move. There's something like 170 million refugees, according to the UN figures. And that phrase could cover anybody in Afghanistan, anybody in Sudan. And when they are able to actually make the journey, and you see a massive people smuggling industry which is coming on using the 1951 UN Charter as its basically legal modus operandi. So I have reluctantly come to the conclusion that it is time to pull out of that convention, because like a lot of laws, it has started to sponsor the sort of evil it was set up to eradicate. The UN 51 Convention has started to offer the legal protection that a people smuggler will give to somebody from Eritrea, saying, look, here is the law. If you pay me $15,000, I can take you to Britain, and if you get ashore, you've got a 99% chance of staying. I think the people fleeing Sudan and Eritrea are logically quite correct in taking up the people trafficking there. But what we're seeing now is the people traffickers taking over the UK asylum process. So I think we cannot offer accommodation to everybody. We are full, that's why we're using hotels. Hotels are only ever used as a very expensive £170 a night last resort when there's nowhere else to accommodate the asylum seekers. And worst of all, we're losing democratic consent. The average voter is looking at the hotel situation thinking, this is just crazy. We need to do something differently. And if Keir Starmer won't, we're going to look to a party like Nigel Farage who will. So you're getting people like Ken MacDonald, David Blunkett, Jack Straw, Malcolm Rifkind, grandees who are saying that the current system is not just failing, but it's failing on a scale which is inflicting damage on communities, which isn't fair on the refugees, isn't fair on the taxpayer, and it is now undermining faith in democracy and fueling support for populism.
So, Fraser, for you, just to clarify, you've changed your mind on this issue. Is it just the UN Refugee Convention that you would want to leave, or is it also the ECHR?
Well, I basically don't think the ECHR serves a purpose. I don't think an advanced democracy as Britain, the mother of all parliaments, needs to have Strasbourg as a backdrop protecting human rights here. But that said, I don't think any purpose would be served by pulling out of it. I think it's a bit like political Jenga, that when you pull out a certain block, other things might collapse that you don't quite realise. The Good Friday Agreement is underwritten by ECHR, as are lots of other things. So when you look at...
That has been part of the recent political mess around this. I mean,
it has, and I support that.
Just explain for listeners sort of why it risks the Good Friday Agreement.
Right. Well, because it was part of the architecture that agreed peace in Northern Ireland. You see the ECHR referred to or baked into clause after clause after clause. So if you were to take it away, you would have to do a lot of extensive surgery to put something approximating it back in. But My problem is that if you look at the countries getting it right, Sweden, for example, has got net zero migration. Now, they've achieved that while being members of the EU, let alone the ECHR. You've got Denmark, which is very tough on asylum seekers. If you turn up with jewellery there, you can have that jewellery confiscated to pay for the cost of your hotel. They've got a policy of net zero asylum. That is very hardline. This is a social democratic government, which is, by the way, being voted in time and time again and looks set to win the next election as well. People are able to change their asylum laws, to change the immigration practices within EU membership, let alone ECHR. So this is why I'm against pulling out of it, because I just think it is a false god. It is a button which won't do the things people think. It's a bit like Brexit itself. It seems radical, it would be very dangerous, it's controversial. And I think there's a bit of a false logic for people thinking, well, because it's so radical, because it's so controversial, of course it would solve these problems. But it wouldn't. So I haven't changed my mind on that. I've never had any real regard to the ECHR. I see it by and large as a needless and quite often malign influence on our judicial system.
Why malign?
Because when you have got a foreign criminal who obviously should be deported and he's allowed to stay here because of some bizarre ruling that his right to family here somehow trumps the right to have him kicked out of the country, which most of the country would like, or people are able to use obviously spurious claims of family connections. You can get people who are estranged from their families, who played no role in supporting the children, and yet still can invoke the ECHR to stay here. Now, I think this is malign because it undermines faith in the legal system. It fuels support for populism and it brings forward, I think the ECHR is an inferior court, and I think the British justice system, the English justice system, is incredibly good and of far higher quality. So anything whereby our judges need to defer to a Strasbourg ruling, I think is a corruption in our legal system and undermines public support in it. This is why I wouldn't be against pulling out of the ECHR if somebody really wanted to do it. But I just think it's so much hassle and it wouldn't achieve what we needed to achieve. I just think that England has got complete power over the laws. Parliament is supreme. Whatever the king enacts through Parliament becomes law. That is our constitution in a sentence. So we can do all of these things without necessarily pulling out of the Convention of Human Rights. But what I've changed my mind on is the Refugee Convention. I used to think it was a worthwhile moral endeavour, but now I think it is now sponsoring a new giant evil of our times, and that is people smuggling. If we were to pull out of that, we could say that we're going to set our face against the modern slavery in the way that we did the last slavery. And I think Britain, unlike lots of European countries, has got the power to do that. But I think it needs to come from the left. I think that the motives of the right are always going to be suspect on this. So I think the stars are absolutely aligning for a campaigning, progressive, left-wing person, the likes of Keir Starmer, for example. He's legal expert, he could do it. He could modernise asylum law for the 21st century and start by working out that, yes, Britain does have a moral duty to the world's dispossessed, but how do we best discharge that? If, for example, we can help 20 people in camps for the cost of helping one person in England, where then do we best discharge our limited resources in helping people? So I think this whole question needs to be rebooted and looked at afresh, from a starting point that we are a strong, rich country. We do have a duty to help the world's dispossessed. But how do we do that in a way that doesn't play into the hands of people smugglers? And how do we do it in a way that doesn't erode public confidence in our own courts and in the system of asylum? And right now that balance is so wrong. It is absolutely fueling not just populism, not just what Nigel Farage is doing, but a hell of a lot worse besides. I can't think of a time where far-right, genuinely racist messages have had more of a platform in our country. I think that Twitter, which is now, or X, which is now a big news source than any newspaper, is now platforming racist tropes on a day-to-day basis. And I think the situation is quite serious. So there's an expression which you hear in America: if liberals won't control borders, then fascists will. Now, I would slightly rephrase it. I would say that if centrists don't reform borders, then populists will. And I think that is the choice Britain's facing right now. I would far rather that this was done by the centre-left or centre-right than we were plunged into a Faragist experiment, which I do not think would lead to success. I think it would lead to far more political trauma. But above all, I'd rather we didn't get to that stage.
That was Fraser Nelson, columnist at The Times, and Jonathan Ames, our legal editor. You can follow the whole Westminster row over asylum and the ECHR online at thetimes.com and follow the debate on Times Radio. The producer today was Hannah Varrall. The executive producer was Kate Lamble. Sound design and theme composition were by Mal Lassetto. Thanks for listening. We'll be back tomorrow.